I don't think the person who's drafted this actually understands what they're doing.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, construction lawyer and contract brevity expert Sarah Fox tears down a standard construction consultant agreement. Sarah has strong feelings about lawyers thoughtlessly copy-pasting and teaches those lawyers how to build contracts focused on what really matters. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. The purpose in this show is exactly what it sounds like. We take contracts, we beat them up. We're usually mean, occasionally nice, but today we have Sarah Fox. And she's just mean. We're just going to be mean. Sarah, how are you today?
I'm fine. Thank you very much.
In the afternoon in the UK, it's morning here. It's cold. All my vegetables are dying, and I have to find a new hobby. I bought a Vespa, and I think I'm going to learn how to fix the Vespa, or just curl up in a corner in a ball of depression. These are my options. So, speaking of depression, today we are going to talk through a document. That was a pivot. Do you see how professional that pivot was? We're going to talk about a document, a standard terms of contract. Let me share this with you guys. This is it. It's a few pages. Sarah, what is this thing? What is this document, and why are we talking about it?
So we're talking about it because it's kind of on the surface. It's only 2 pages, couple of thousand words. Looks like it kind of should be simple, but it's obviously a bit of a cut and shirt. They've kind of taken clauses from things that they've seen. They've copied and pasted off the internet. They've put together a sort of mongrel beast of a contract. And I don't think the person who's drafted this actually understands what they're doing. I don't think it's been written by a lawyer, or it's not been collated by a lawyer, but I think some of the clauses have clearly been originated by a lawyer somewhere in the internet.
Yeah.
So just to have a look at why people put this stuff in their contracts.
It reminds me, some of these contracts remind me of the AI generated, novels or whatever, or scripts. There's this awesome one that's a sci-fi script. You guys have to find it, where they actually recorded a movie recording of it. And it's hilarious because things just sort of none of it makes any sense. So I love these sort of human/AI generated documents. But Sarah, why are we talking to you? Tell me about your background and what brings you to this awful document.
Well, I started as a construction lawyer in the UK, and I practiced construction law for 20 years. And in that time, I looked at a lot of contracts. We use a lot of standard form construction contracts in the UK. They're roughly 50,000 words, kind of small novel length. But I'm also a dual qualified trainer. And as I was training people on contracts, I realized that not a single person had a Scooby-Doo what they meant. So the lawyers didn't know what the contracts meant. The clients didn't know what the contracts meant. It looked like we were just generating paper because we didn't like trees. So I decided to kind of challenge myself to come up with a training tool that could get people to start talking about what ought to be in a contract, and then how you could finesse it, how you could make it work for them. They kind of started to like it. So then I had to justify whether or not it would be a legally effective contract. And then people still didn't believe me. They said I couldn't do it. So I wrote a book to explain why I could. So I've now written a few books to explain how you can write a contract in 500 words, rather than create this kind of pick and mix approach of going to the sweet shop of clauses and just chucking a load of stuff in, and then finding out you can't afford it in the end.
I require through the rest of this conversation that you continue to use British aphorisms that we don't know what they mean, because nobody has a Scooby-Doo is like, I don't even know what that means, but I love it. So we're going to go to the document here and talk through some of these sections. Let's start with 4. So this document, before we get to it, if I'm understanding correctly, this is like a company is hiring a construction contractor, somebody who's going to do, because it uses the word consultant. When this document is using the word consultant, tell me what does that word mean in this context?
I think they mean somebody who's providing services, not works. So it could be a designer, it could be a planner, it could be an engineer, it could be a cost consultant, a quantity surveyor. Somebody who's not actually doing any work on the site, but is helping to administer that whole project.
Well, and to the big point that I know we're going to get to, they may use this for all kinds of people that this actually doesn't make sense for. So let's start with 4. The phrase in this one is the consultant shall exercise reasonable skill and care in the performance of the services. Reasonable, the word that holds up the entire common law legal system. What do you think about number 4 there?
Number 4 is just the worst possible sort of clause, because basically you're saying you're going to be averagely competent. Now, I don't know about you, Mike, but I don't think you'd ever get a job if you put I'm averagely competent in your CV. And yet that's all they're promising to do. But the other thing is the client doesn't actually care how much competence you've got and how much you put in. They want the product at the end of the day. So they want the report, or they want the designs, or they want all of that stuff. And they want it to meet their expectations. There is not a single reference in this contract to the client's expectations, their needs, any deliverables, the outputs. It's just focusing on kind of being average as you go in. I don't know. I don't want to spend my money on people who are just going to be average.
Especially when you jump down to 9. And this is a long one. I won't read it to you guys, but we'll share it on the screen. This one is a limitation of liability. And it says that, this is awesome, that it shall not exceed amounts recoverable by the consultant under the professional indemnity insurance policy. So they're basically saying, we're going to be, okay. And if we're terrible, call the insurance company. What do you think of 9?
Well, there's a few problems with 9. First of all, there's no promise in this agreement anywhere that they will have insurance. So that if they don't have insurance, you won't find out until you've got a claim, in which case your limit of liability is the amount they can recover under a non-existent insurance policy. This is definitely like kind of playing a game of football in the dark or blindfolded. It is just going around in circles. So you don't know how much their insurance is. You don't know what the restrictions on it are. You don't know whether they're going to have it. Because professional indemnity insurance is on a claims-made basis, which means you got to have it for all the years in which you might want to bring a claim. If they haven't got it anymore, you've got no recovery whatsoever. So basically they're saying, we're going to promise you average, but if we're not average, you can't even claim from us. Hooray!
Hey everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. Number 10. Now, this one's like a line straight out of Downton Abbey. Without prejudice to Clause 9, the liability of the consultant for any claim or claims shall be further limited to such sum as it would be just and equitable for the consultant to pay. What do you think about 10?
So number 10 is one of my pet hates in consultant appointments. It was driven by insurance companies, so nobody would have thought of this off their own bat. But the idea is that what used to happen, particularly in the UK, is the consultants who had the best insurance policies got all the claims. So if there was a number of different consultants working on a project and somebody had £10 million worth of PI and somebody had £500,000, the person with £10 million would get all the claims. And they would kind of go, well, this is unfair. We've protected ourselves. Why should we get all the claims? We want to divvy that out. We want to share it out amongst people. So they came up with this clause, which is called a net contribution clause. And basically it says we're allowed to divvy it up, even if the other parties don't have contracts with you, even if the other parties have become insolvent, we're not going to pay any more than our share, our fair share. Now, the problem with that is, how do you negotiate what a fair share is? Because by the time you're in dispute, you're going to have to call a judge, it's going to get complicated. But interestingly enough, this clause also goes on to say, on the assumption there are no limits on their liability, in a contract which has this weird limit on their liability. So it's like, hang on, other people have got to have a better contract than us, but we're still going to give them some of our compensation. It just doesn't sit together nicely. It's all going to result in multi-party proceedings, which are the most complicated and expensive proceedings you can get. This is a hiding to nothing.
Yeah. And I mean, I'm looking at sub 1, 2, and 3 in 10. As you said, it goes on and it talks about these these different, like how they're transferring the insolvency, the non-payment stuff, it gets quite confusing. In 11, there's a lot of language in here about due date. There's also final date. There's just language that's sort of bouncing around, and you know, it defines duties, but with these sort of vague dates. What do you think about 11?
Well, 11 was driven by a piece of legislation that we had in the UK for construction contracts, and that includes consultant appointments. But the language used in the legislation is pretty poor. When it talks about a due date, it's not when the money is due to be paid. The final date is the date when the money is due to be paid. So we have all these kind of terminology. There's a whole load of definitions used just in this clause. But the problem is, although they've used the terminology to be consistent with the acts, and that's kind of good, it's almost impossible to understand unless you know the acts. Now, you have to read 4 different pieces of legislation to really understand it, and nobody's going to go off and do that. So this could be just way more user-friendly by talking about, you know, submitting an invoice, when it will be paid, and then just saying that's when you're going to pay, not this final date, pay less, pay. You know, the terminology is just too gluey to actually use. And the purpose of payment provisions for a consultant who's drafted this is to make sure they get paid. So, you know, why aren't they making it simple for somebody who might not be a sophisticated consultant, might not have never read these acts of parliament? Why aren't they just making it easy to get paid?
Yeah.
Why wouldn't you?
Yeah, well, speaking of, 12 has the stick, right? It's the penalties for not having paid. Tell me about 12. Do you like it?
Well, there's a piece of legislation which came out of Europe when we were still members of the European Union, which looked at interest on late payments. So that if somebody didn't pay you on time, you're entitled to some form of interest. Now, that was set at the maximum rate of 8% above base. And most standard clauses don't go anywhere near that because interest rates in the United Kingdom have been historically low. You know, they're running at sort of 1%. So sure. 8% is kind of a massive increase. But this not just says we're going to get 8%, the most you could possibly get. But on top of that, we're going to get any other sums we pay to recover that debt. And it doesn't say reasonable sums. It just says pretty much we can appoint the Queen to come and get our debts off you. And, you know, if she's very expensive. So, but we're still going to charge you that. Now, This is a consultant appointment. There's probably not a lot of money at stake. So it's kind of a sledgehammer to crack a nut at this point.
13 comes back to talk about liability and dividing liability. What do you think about 13?
13's a really weird one. So 13 is basically saying, you, Mr. Client or Mrs. Client, can tell me that I ought to appoint some people to carry out services that are in my scope, but you want me to use them because, say, they're your bathroom specialist or say they're your favourite geotechnical engineer or whatever. So I have to appoint them. They have to be in contract with me, not you, because you don't want to be responsible for them. But then if I've taken them over and I don't even understand or know them, I'm not going to be responsible. But that's not how contracting works. So between the client and the consultant, they'll always be responsible. And this clause kind of seems to try and undermine that. It's a weird one. I understand why clients sometimes want not to have too many contracts that they enter into. But if I was a consultant, I would not be happy with being forced to use one of their sub-consultants.
Got it. 14 gets into termination, breach. What do you think about 14?
14 is it's literally 2 lines. 2 lines to say, if you're insolvent or in material breach, then we can terminate. Termination's a really serious and, you know, it's an end game, isn't it, for all these kind of things. You shouldn't be allowed to divorce easily. I get that. But you should be really clear what material breach means. You know, insolvency, I think we can get that. It's failure to pay your debts, you know, that kind of thing. But material breach, I don't think we want to be arguing what it means to check whether or not we can do it, because this is a point at which if you get it wrong, you know, catastrophic circumstances arrive at the party. So, yeah, I think they need to be just a little bit clearer. I mean, for example, all they need to say is if you fail to pay our fees for 2 months or whatever, or more than £10,000 or whatever, we can terminate. If we fail to turn up to work, you can terminate. That's all you need. You don't need material breach and then to try and get a lawyer to tell you what that means before you can do what you need to do. So you know what? That's why I said it. Although it's short, it's still really gluey.
Yeah. Yeah. 19, I'm going to jump down to a sentence that's pretty shocking. It says, for the avoidance of doubt, any notice sent by email shall not be an effective notice under this contract. This thing is dated 2015 and telling us that we can't use email for communications that are legally binding. What do you think about that?
But why? Why do we not allow email? Maybe if it's a serious thing like terminating the contract, you want them to follow it up with a hard copy just in case your server goes down or somebody's cancelled your email or your internet fails or whatever. But at the same time, saying that all other notices under an agreement which needs a lot of to and fro, construction projects require a lot of to and fro between parties. This is not like a one-time buying of goods, then you might return them because you're unhappy with them. That's slightly different. But this is a real to and fro relationship. And the idea that you have to send everything by hand, so you have to hand deliver it, in a pandemic, good luck with that, or Royal Mail special delivery, wow. How to make life difficult for yourself in the 21st century.
Yeah, hold on a second. I need to plug my fax machine back in. I don't know if lawyers of all people should be the ones criticizing how people send information. But I mean, we're at the point where people are like mostly communicating by text and we should be having a conversation about text. But I feel like email should be established by now. All right, last line. Tell me about this one. The work will be carried out on the understanding that these standard terms of contract have been read and agreed to. What do you think about that sentence?
So this is another one of trying to use your terms to replace a poor contract process. So, contract formation happens when there's been an offer, acceptance, all that kind of stuff legally. But actually, either they've signed these or they haven't signed them. Either they've read them or they haven't read them. And just saying, oh yeah, you're deemed to have read them, or it's on the understanding that you have, doesn't mean that they'll have read them. And if the purpose of a contract is to help us do business, then we need to read, understand, and use them. Now, it's really interesting. I had some data recently. The World Commerce and Contracting looked at how many contracts end up in serious dispute. So not necessarily in court, but serious dispute. It's less than 0.07% of contracts globally that end up in dispute. So we got all these clauses that try and tie us up in knots, and there's loads of them in this short contract. But actually, they're not helping us manage the project. Right. This is almost all about the legal stuff. And that's going to happen on 0.07%. The focus is all wrong for me in this. It doesn't actually help build trust, describe what the parties want to do, say what the client wants to receive, or deal with any of the kind of risks of working together on a project.
Right. Yeah, it's interesting, like that data point, because it's sort of like, well, not sort of, it is literally like this contracting exercise is not a legal process, it's a business process. This is a form of communication that we're going in and adding complexity to it that, doesn't really mean much to the business process.
It has no value. Yeah. These pieces of paper are having less and less value to businesses as they realize that they never do things with them. They'd spend a lot of time negotiating them, paying for them to be drafted, paying for them to be adapted. Yeah. And actually, they very rarely use them because they've got good commercial relationships. And if they haven't, well, maybe they'll be able to write it off and, go and do something more interesting than suing someone.
Yeah, it reminds me of the days back when I worked in logistics. Like, if you guys realize the majority of commerce is done with things that are like, what are you delivering? How much? When? Basta. That's it.
Yeah, and interesting. I was sorting out my mum's effects and found an invoice from a big company in London who was sending furniture to the Isle of Wight, where my mum used to live, so off the mainland of the UK. And their terms and conditions, literally 4 lines. And it's like, why have we got so far away from this 4 lines?
This is why everybody loves hanging out with lawyers. Well, and I want to get to that because, your thing is to talk about trying to limit contracts, trying to get the language down. And, I sort of feel like what we're learning from this is brevity is the soul of wit, but that doesn't mean brevity is wit. Like, just because you cut something down doesn't mean that you did the real work. Talk to us about the big picture of how do you do that exercise of saying, all right, I want to cut this down and I want to be plain language and I want to do that exercise. But in a way, it's actually much harder because now I have to make conscious decisions that before I was just copy paste.
Yeah, completely. So when I decided to try and do a contract in 500 words, first of all, I wasn't sure I could do it. So, I spent a long time making sure I could before I branded my business that way. But one of the things I wanted to do is look at what do I absolutely need in a contract? So I split that into sort of 10 different things. I needed to know what they were doing, who was doing it, what processes, like change management processes, what risks, how we might limit liability. I looked at the sort of things that case law, because we have a common law system in England, might imply in. So we don't need to deal with that, particularly if it's really well known. I looked at the sort of things that Acts of Parliament might add in that we didn't need to deal with. But I kind of tried to focus on what clients cared about rather than what lawyers cared about. So all the sort of boilerplate clauses, the sort of stuff you've discussed on your show before, sure. I just basically threw them out. And the lawyers went, oh, you can't do that. It's like, yeah, but people are doing it all the time. We've got these copy and paste, cut and shut, pick and mix contracts that people are writing off the internet all the time. Why not give them at least a structure that allows them to have the bare minimum right? So that's kind of my justification for getting rid of, 95,000 words.
Well, and when you do that, I'm sort of wondering, do people actually read it? Like as a part of the process, when you're doing these sort of documents, you feel like, I got to cover all the bases. I got to plan for all the things and put them all in the document. But you're almost guaranteeing that for the contract purpose of setting expectations, of getting everybody on the same page, like the social function that a contract should, serve, which is building the trust that enables commerce, that enables collaboration between people, that in fact, you're making it like the more you go on, the less people are actually going to read it. I sort of feel like this kind of thing, if you get to the crux, what you're really saying is, we're going to get down to the things that enable the commerce that we were going after in the first place. Yeah.
And you avoid that thing of people not trusting it because there's small print, or it's hidden somewhere in the documents, or they haven't read it, or they didn't quite understand it because you couched it in legal jargon and just an equitable and without prejudice to the general, all that kind of archaisms that we just don't need. If you have 500 words, which is literally a side of A4 in decent font size as well, not just teeny tiny font. So why wouldn't somebody read it? And in order to do that, you don't have room for archaic language or foreign codes or copying and pasting. You have to make it clear and obvious and impactful. So it has to be immediate rather than sort of skirting around the houses. We don't have 500 words, doesn't give us any time to skirt around the houses at all.
Yeah. The enabling power of constraints. I mean, you set those things and you got to work in it. So hard decisions. But so for people who want to learn how to do this actively, to think actively about the way they're, using language, not as precedent. I love the word that we use. Oh, we've got this precedent, which is really fancy code for word copy pasting and not really making a lot of decisions. But for people who want to learn from you how to do that, what's the best way to reach out to you, Sarah?
So I have a blog called 500words.co.uk, but also I have 4 books on Amazon that cover sort of construction things. They deal with consultant appointments, they deal with small works contracts, and a couple of other construction ideas. But actually, they're not just the ideas aren't limited to how you would structure a construction contract, because they talk about what needs to go in, why it's in, what happens if you don't put anything in your contract. And, really it's about trying to get people to think differently about the purpose of their contracts. Is it to help them do business, or is it to feed lawyers need to pay off their student loans? You decide.
One day we'll write the philosophy of law book that says, guys, it was all about trust. It was all about building trust so people would collaborate. I love it. So we'll make sure to include all that contact information in the post at lawinsider.com/resources that corresponds to this episode. We'll have your contact information and we'll have this document so people can look it over. Also, if any of you want to join us and be a contributor on the Contract Teardown Show, just email us. We are at community@lawinsider.com. We'd love to have you. Sarah, thank you for being with us. Thank you for the Scooby-Doo and other aphorisms, and we will see you guys next time. Have a good day.